This seems to be a quote joke to the defense, in line, so to speak. I would ask that the court keep bond as is, allow Judge King to go back on the record on January 7th and allow Judge King to make a ruling on bond as he has intended to do. Thank you.
So returning the argument to, or I shouldn't say returning to, viewing the parties' arguments within the scope of the bond test, and giving the previous bond history on this particular case, I do believe the flight risk component of that test, that the examination of the behavior of Mr. Johnson indicates a failure in that regard. Mr. Johnson has been remanded to, or not remanded, but has had his bond conditions altered by a previous jurist due to his non-compliance with the original bond condition. I think that Judge King is a diligent and well-respected peer of mine, and I do think that even with the $75,000 cash for surety, that's a pretty reasonable bond for an armed robbery, which is a capital offense. So we have a defendant who is facing a capital offense and is non-compliant with bond conditions already. He really has set himself up in a very bad way as far as bond argument is concerned, Mr. Greenwood. I mean, Greenwood, I appreciate your hard work and your advocacy on behalf of your client, but he really kind of self-destructed on this.
Well, Your Honor, the thing is, the facts of the case regarding this don't fit the normal aspects. Apparently, the complaining witnesses went to a gas station in order to buy marijuana where this particular incident occurred. I have been trying to get from the prosecution an alleged green light video, which is supposed to show a part of this particular incident. I didn't get the discovery of body cams and in-car videos until last week.
So, Mr. Greenwood, I do respect the fact that your client is not guilty of anything, but it is the severity of the approach that is necessary when facing and developing a defense for yourself on a capital case where your client may very well be found not guilty of. But because he has shown a lack of seriousness in the approach to this charge, which sways the court does not feel that this is serious. I mean, bond conditions on a capital offense. I mean, what? There's nothing left. There's nothing above capital offense.
Well, Your Honor, I have met him many times. And
your client chose not to approach this with the seriousness, and what he doesn't understand that his lack of seriousness is going to be viewed within the lens of the two-pronged bond test.
Your Honor, as I indicated, that he's been attacked by another prisoner at the jail, and I don't know how good of a situation that's going to be going forward. And I got that information from the
Mr. Greenwood,
commander.
I don't feel that you're being untruthful. The problem is he was out of jail. He wasn't in there. Jail was not his problem until he decided not to be diligent and approach intelligently the charges that were levied against him by the people.
Well, Your Honor,
jail was not his problem. Jail would not be a problem if your client would have played by the rules. excuse me, played by the rules. So the bond is continued as is. I'm not altering any future dates. I believe it's January 7th, 2021. Defense motion denied. And, all right, the parties may continue on. Mr. Greenwood, enjoy your holiday, sir.
Thank you, Your Honor.
Welcome. All right. Trying to figure out who Mr. Brinker is on. I don't see his name in here. Is there Attorney Shadreu? Is that a familiar last name, Ms. Shannon?
George Shedrow, yes,
Oh, shit.
it is.
Okay.
I don't see him on one of my cases, but he may have been retained in on something.
Counsel, Mr. Shedrow.
Hi, Your Honor.
Yes, who's your defendant?
James Coleman.
Yes. All right, hold on a moment, Mr. Shedrow. Mr. Brinker, who are you appearing on, sir?
I have Fowler, Javier Fowler. With X.
That was the one with Mr. Shariki.
Oh, you. All right, Mr. Brinker, you're
I'm retained.
retained.
Correct. I'm sorry. I was bouncing from one room to another. I was in earlier, but I was in the waiting room.
All right, so the point that appeared that Mr. Shariki, I know you know Sam Shariki.
Yeah, it's not.
So he wasn't concrete on the retainer or not. So the PCC was just adjourned just in case to, what was the date?
April 13th.
April. So the PCC was adjourned to April 13th.
That's fine. Yes, that's fine. Thank you. That's perfect.
Yeah.
And-
All right. April 13th it is.
Thank you. Thank you.
Tyrone,
Ms.
I'll get
Seamus?
discovery to you. I have paper and 2-zip files. I'll get that to you in a few moments. And I wanted to let you know that your client may be appropriate for diversion.
He very much is. So that's why I want to go ahead and get that knocked out right away. He's almost got every single thing that you guys are looking for.
Right.
So, in fact,
Right.
I may even ask for outright dismissal. Thank you, Ms. James. Thank you, everyone at the court. Have a safe day.
All right. Thank you.
Have a good
Enjoy
day.
your holiday.
All right.
All right, returning to you, Mr. Shedrow. You're representing Mr. James T. Coleman.
Standing in for the attorney record, Jeff Schwartz. No big
Okay.
deal.
Is Mr. Coleman in the waiting room? It appears not.
And I just know that Mr. Schwartz says he does not have discovery.
Waive his appearance. I'm going to call the case now.
Okay.
Now calling 1-805-727-2001. People v. James T. Coleman. One count. Habitual fourth enhancement. This is 12/23/20. Appearances, please.
Good morning, Your Honor. May it please the court. Danielle Seamus on behalf of the people.
Please, this honorable court, George Shedrow, P41732, on behalf of Mr. James Coleman, Your Honor.
And Mr. Shedrow, you making a motion to waive your client's appearance?
I would ask that the court allow me to proceed without my client's appearance. Yes.
Motion is granted. Today is the probable cause conference. Your client does have a right to a preliminary exam, which is a probable cause hearing. In this case, the law also does allow for the waiver of that examination. At this point in time, sir, the exam dates would be in June, the middle of June.
That's fine.
So is the defense demanding an examination at this point in time?
Yes, we are.
Our exam will be set for 6/17/21 at 11:30 p.m. Excuse me, 11:30 a.m. Anything additional from the parties at this point in time?
The only issue would be discovery, and I know Ms. Seamus will send it over.
So the bond will
Yes,
be
I sent it
continued.
yesterday, but I'll resend it.
Okay.
Excellent. All right,
Thank you.
bond is 6/17/21 at 8:30, excuse me, 6/17/21 at 11:30 a.m. All right, the parties
Thank you.
may continue on. You are welcome.
Everybody have a good holiday.
You too.
Enjoy yourselves. Bye-bye.
Absolutely. Yes, counsel, good morning.
Good morning, Your Honor.
And you are appearing on,
I've got Eric Thomas. I'm standing in for Attorney of Record Lance Mermel, Your Honor.
Eric Thomas, Eric Calvin Thomas II. All right. Calling the case 2-0-0-6-2-0-0-7-0-1. He will be Eric Calvin Thomas II. Total of 1 count for the court. Appearances, please.
Good morning, Your Honor. May it please the court, Danielle Seamus on behalf of the people.
Good morning, Your Honor. Romy Mezzi, P68245. Your Honor, I'm standing in for Lance Mermel with Mr. Thomas' permission.
All right. And this is probable cause conference. Your client does have a right, statutorily provided right to a preliminary examination in this case. Preliminary examination date will be either June 17th or June 21st. There is a right, the law also does allow for a waiving of that preliminary examination. And Mr. Mezzi, what is the defense attempting to do for their client today?
Your Honor, is it possible to get another probable cause conference date for discovery and to see if we can resolve this matter?
I'm disinclined to do that just because I think 6 months is enough time for everything to kind of get figured out. Because I mean, if you set a probable cause date, that'll be in April. And if you want to set the exam, yeah, that's how far out the PCC adjournments are. And then if you want to set an exam then, now you're probably looking in August.
So
that'll be like a year old on a case on only 1 count.
Your Honor, if you give me the June date and I want to bring him in sooner for a waiver or resolution, would I be able to do that?
Say that again, Mr. Mezzi, one more time.
If you give me the June 17th date and I wanted to bring him in sooner
Absolutely. You want to bring him in early because you know it, because the defense and the prosecution became super focused and know exactly what they want to do and want to come in early and put it on the record. Yeah, just give the clerk. Just give the clerk a call ahead of time, and they'll tell you what day is kind of a light day on that for that week. And boom, walk in, put it on the record, done. You know what you're doing. That's perfect.
Thank you, Judge.
It's perfect. That is totally perfect. And then if you can't get it done, you come in and hold the exam.
We'll get it done.
Perfect. That's what I'm talking about. That's how you get cases done. And it's great because you can get with the parties ahead of time You can pick the most convenient day. It's low stress instead of
Exactly.
scratching. Exactly. So it's a 617 or 621, Mr. Mizzy?
I'll take that 617.
All right, 6/17/21 at 11 a.m.
Is that a person?
Our bond is continued.
Is that a person?
What is that?
Is that a person?
And right, so wait, he's out of custody, correct?
He is, Your Honor. I'll waive his presence if he's not there.
All right, no, yeah, wait, we're in. Right.
And you-
6/17,
Could I just ask the process? I'm sorry, Your Honor.
6/17/21, 8:30 a.m. Bond is continued. What was that, Mr. Mason?
Could I just ask the prosecutor to send me that evidence.com link?
Yes, I sent it to Mr. Mermel yesterday, but I'll send that to both of you today.
Thank you so much, Ms. Seamus.
All right. The party's
Happy
ready.
holidays, everyone.
Enjoy your day.
Take care, Judge. Nice seeing you.
Always a pleasure.
Thank you.
I need something else. I need to sign this over. I gotta get it.
Okay. Gary Anderson is an attorney, I believe.
That was the last two.
Yes.
I only have 2 people left. I only have 2 files left, but there's like 6 people in the waiting room. All right, knock, Mr. Anderson.
Yes, sir.
Mr. Anderson, good morning. Who is your defendant, sir?
I have Cassandra Lopez. I don't know if she's present or not. I have not been able to reach her. The number that I was given is her mother's, and I can't get any.
All right, Cassandra Lopez, not Lopez, but Lopez. Okay.
Lopez. Yep.
There's a little bit of a misspelling here, but that's not a problem.
I'll correct it.
This is 200-619-8801. People v. Cassandra Lopez. 1 ticket, 1 count. There is a second offender habitual enhancement and commission of a felony with a motor vehicle advisory. Appearances, please.
Good morning, Your Honor. May it please the court, Danielle Seamus on behalf of the people.
And Gary Anderson on behalf of Ms. Lopez, P27210.
And this is time and date for a probable cause conference. The defendant has a right to a preliminary examination that is provided by statute. The law also does provide for a waiving of that particular hearing. At this point in time, what is the defense hoping to do? Mr. Anderson, the exam dates at this point in time are as far out as June. If that's what your client is not in custody, correct?
That's correct, Your Honor.
And what is the defense attempting to do today?
Your Honor, I have received discovery, written discovery. What I don't know is whether there's any digital. That if there is, and since I'm not able to reach my client to consult with her at this point, I would request either a post-holiday an adjourned probable cause hearing, or I request an in-person exam.
So the in-person exam is set for 6/21/21 at 10:30 a.m. Bond is continued. I'm sure that's enough time, Mr. Anderson, for you to resolve all the discovery issues with the the prosecutor's office. And if there's order from the parties, this hearing can conclude.
It was uploaded this morning.
Digital?
Thank you. Mr. Anderson, the video was uploaded. Yeah, it was uploaded this morning by the officer in charge, so I will get that to you shortly.
Okay, thank you very much. I appreciate it.
All right,
You're welcome.
21, 10:30 a.m. Bond is continued. The parties may continue on with their day.
Thank you, Your Honor. Merry Christmas to you and your staff, and happy holidays as well.
Yes, Merry Christmas, Happy New Year.
Take care. Thank you.
You too, Mr. Anderson, enjoy your day. All right, Ms. Seamus, I am,
Yes.
Mr. Thomas, good morning again, sir.
Good morning.
Mr. Thomas, your attorney has already appeared on your case and taken care of everything that needed to be taken care of today. At this point in time, you are remaining not guilty. I imagine you will be hearing from your attorney shortly. At this point in time, sir, you may log off and continue on with your day.
Okay, thank you.
You are welcome. All right, so somebody, I think Jonathan Hill. Is Jonathan Hill, does that sound like a neighborhood services attorney?
No, that was the defendant by, represented by Tanisha Reed.
Oh, they weren't even, he wasn't even checked in when we did that case. What about Antonio Williams? Is that a neighborhood service?
I don't recognize it.
Right.
No, I don't recognize that name
There's the
at
last-
all. I'm
there's
not
only-
sure who that would be.
There's only one person who we have not, and that's somebody named Yale Khalid Yancey.
Right.
So let me bring them in and see who their attorney is. These other two names, well, Mr. Hill can be dismissed. Miss Yancey,
Yes.
good morning, madam. Miss
Good
Yancey,
morning.
who your attorney, the name of your attorney?
Can you say that one more time?
Do you know the name of your attorney?
Yes, Brian.
Brian.
Yeah, I can't really pronounce his last name.
Your Honor, I believe that, is it Brian Gagnick?
Yes,
Is it
ma'am.
Brian Gagnick? Okay,
Oh.
Your Honor, I can reach out to him really quickly. Try to get him on here real fast.
Please do that. Miss Yancey, I'm going to return you to the waiting room for now. So we do not have a Williams on the docket for today, but Mr. Antonio Williams is there. Antonio Williams. Mr. Jonathan Hill. Can you hear me,
Hello?
sir? Mr.
Yes, sir.
Hill.
Yes, sir. How
Your
you doing
attorney,
today?
your attorney, Ms. Reed. Hold on. Mr. Hill, your attorney, Ms. Reed, has already appeared on your case and done what was necessary for today. She appeared very early this morning to take care of your case. So, Mr. Hill, I believe you'll be hearing from her shortly about the next procedure and step on your case. So at this point in time, you are free to log off and continue on with your day.
All right, thank you, sir.
You are welcome. Enjoy your day, sir.
Can you ask, you said it's an Antonio Williams?
Yeah.
Can you ask him his date of birth? I think he got the wrong date.
You gotta put a shirt on. And he's not connected with the audio. I can't even tell him to put a shirt on. Okay. One remaining case.
Your Honor, Mr. This way.
If his date of birth is April 23rd, you're on the wrong date.
All right. Miss Yancey, that's whose case is left.
Yes, Your Honor, Brian Gagnon.
All right, bringing in Miss Yancey now. Okay, there's Miss Yancey. Okay, calling the case, 200-6199301, People v. Callie Yancey. One ticket, one count with a motor vehicle one information, one charge with a motor vehicle advisory. Appearances, please.
Good morning, Your Honor. Danielle Seamus on behalf of the people.
Brian Gagnon, Your Honor, Neighborhood Defender Services.
And Miss Yancey, state your name, please.
Kaylee Yancey.
Kaylee Yancey. Time of day set for probable cause conference in this particular case. The defendant does have a right provided by statute to a preliminary examination, which is a probable cause hearing in this case. The law also does allow for a waiver of that hearing. Today is the probable cause conference, and Mr. Gagnon, what is the defense attempting to do today?
Your Honor, I lack discovery, but this also appears to be something that I believe there would be eligibility to the gun board. Therefore, I will lean on the court and ask what you suggest I should ask for.
So, Mr. Gagnon, the exam dates are all the way out in June.
I know.
I know there's a bit of, from what you've indicated, there is a bit of a back and forth. It sounds like that you would like to do to achieve some type of non-trial resolution in this case very early on in the proceedings. 6 months, I think, is a lot of time to be able to accomplish that.
I hope so.
Yeah. Adjourned PCCs are in April. So
To the court's pleasure.
I'll just set it in June. And then you can walk your client in early if the resolution is achieved. And just, yeah, I mean, that's almost, just set it in June, get something early, great. Come in and do what's necessary to get that on the record.
I will keep in contact with Ms. Seamus. I'm sure she knows how to get a hold of me. We'll take care of it.
And Mr. Gagnick, sorry, Your Honor.
Ms. Seamus, let me ask you this. How quickly, under pandemic conditions, the latest and greatest conditions on how things are operating these days, how quickly is the gun board, how quick is the turnaround?
You know what, Your Honor, I'm not 100% certain on the turnaround. I do know that they are reviewing cases every Wednesday. So I think part of it depends on the time with which it takes the defense counsel to get.
No, that's correct, Your Honor. There's a long line.
In one packet. Yeah, there is a long line. But I know they're doing their best. I've had some come around kind of quick, while others are taking a while.
So, Mr. Gagnier, can you get this done by 8?
Oh, absolutely.
All right, so I'll just adjourn the PCC. Do you have the discovery already, counsel?
No, Ms. Seamus and we're in contact. I'm not worried about receiving discovery.
I did send it to the discovery email address, but I will send it directly to you shortly.
I'm sure it's somewhere. I'm not worried.
So this matter will be adjourned to April 15th at 8:30 a.m.
April 15th, 8:30 a.m.
April 15th, 8:30 a.m. Bond is continued.
Thank you. You're free to log off, Ms. Yancey.
Yes.
Thank you.
All right. Bond is continued April 15th, 8:30 a.m.
Thank you. Your Honor, there was another matter that I had set that might have been in this courtroom. It looked like it was the 3 defendant with a cane prior.
Yes, 2 of those people retained counsel.
Okay.
And the other went to Glendon.
Okay, so Mr. Pryor, did he? Okay, I understand.
Who did you have?
It looked like Kane Pryor, Your Honor. Did he retain or did it go to Mr. Glenda?
Yeah, I think he retained.
Great.
Right, two retained and 1 had Glenda.
Understood. Well, that's a good trio. Thank you for everything. Have a good holiday, everyone.
Yeah, same to you. Enjoy your holiday.
Have a good holiday.
You got it.
Ms. Seamus,
yes,
I do believe that concludes the docket today.
I agree. Thank you.
One straight name remaining in the waiting room, but it appears that person's case is not set for today. And that person was also not